The trial of State of Florida versus Charles Adelson has been marked to me by gamesmanship and fundamental unfairness. And what I'm talking about is the entire fact, the ridiculous fact, that a defendant in a criminal case is able to save up an affirmative defense, not disclose it to anybody, in spite of the fact that this defendant, Charles Adelson, participated in discovery. So he participates in discovery, but he lulls the state into not knowing the fact that he's going to surprise everyone by claiming extortion on the first day of trial. The defendant in this case, perhaps because the prior defendants conducted significant discovery and there was a lot of material to review, didn't do almost any discovery. They took one deposition. The defendant spent the entire time not bothering the state, not bothering the prosecutors, and preparing for trial, knowing what that defense would be, knowing that they were going to claim extortion. The prosecutors apparently didn't know that. They had several opportunities as the trial got closer to learn that, but each of those opportunities somehow went by the wayside. There was the compelled interviews of Donna and Harvey that the state was successful in setting up, in seeking the court's help, in enforcing it, in enforcing Donna and Harvey to put on record their position regarding their involvement in the case. This would have happened before trial, would have given the prosecutors a few days to prepare, knowing what that defense would be, because they would have had to disclose this defense, right? The defense of extortion. Yet, somehow, the defense was able to convince the prosecutor to drop this whole effort. This is a trial that has been marked by the element of surprise. The defense wanted to come to trial and did everything possible to preserve the element of surprise, a sort of trial by ambush strategy, where the prosecution didn't know what was coming, did not know what exact issues the defense was going to raise during the trial, and therefore the preparation for the witnesses, the preparation for the trial, the preparation for jury selection was missing essential elements, right? When you're preparing your case, you're preparing the opening statement, you're preparing what issues to address with the jury during jury selection. You should know what the key issues in the case are. Yet, for 9 years, defendant Charles Adelson was able to completely hide this apparent defense. It is a defense in the sense of we made a payment for a hit under duress, right? So they're trying to defend the allegations that they conspired to murder Dan Markel, that they murdered Dan Markel and paid for the hit. That was all part of the conspiracy, right? By claiming that they didn't do any of that and that instead they were forced to pay. So the defense concedes in opening statement that is Charlie's money. But now everything, argues the defendant, should be looked at from a different perspective, right? The state is missing context and misinterpreted all of the evidence. They did a great job getting to Sigfredo, Katherine Magbanua, and Rivera, but they didn't know about the extortion, and therefore everything that happened afterwards, they misunderstand. And then there's very little that happened before, right? All they have about the involvement of Charlie and Donna and Wendi, perhaps, during the day of the murder is just phone calls going back and forth. The strongest evidence, of course, comes from the payment for the hit, the stapled money, that's afterwards, which now the effect of that evidence has been lessened, right? Because, yeah, the jury will believe this was stapled money. The jury will believe that this was Charles' money, right? But because he considered it, but now he's saying, hey, wait a second, yes, I did pay, but I was under threat. Has the state conducted any investigation into this potential extortion that has never been reported to the police? Shouldn't there be some kind of judicial stopple from doing this, right? I mean, it is making a ridicule, in a sense, of the fairness of the trial system, of our justice system. To allow something like that to happen, to me, is pretty absurd, because think of all the waste of judicial resources, of prosecution's time, of judges' times, of trials that have happened because the state had to prove that that Katherine Magbanua was involved, that Sigfredo Garcia was involved. And all this time, you're going to tell me that the Adelsons knew about this, right? And simply decided not to share that with the prosecutors. Why? Because they didn't think that the prosecutors would believe him. But a jury that is limited in what they can hear, a jury might believe it, right? Is that the strategy here? Is to go to trial and to come in there with the element of surprise. The jury selection was a way for the defense to address issues that the state really didn't think were going to be of importance. Perhaps the state wasn't paying too much attention to those things, right? And so, trial by ambush, in a sense, is a bit disgusting. It used to happen a long time ago, and rules have been changed over years to prevent it. Yet in the criminal justice system in Florida, a defendant actually can do this. It's legal. For example, a defendant is charged, and they can just demand a speedy trial and not explain what defense he or she will present. They don't have to participate in discovery. Then if they elect to participate in discovery, the rules mention, okay, now you have to provide notice if you're going to rely on an alibi defense. But why not require a defendant to disclose every single affirmative defense that they may raise, such as duress, extortion, or whatever else they're going to claim? Isn't that better for the justice system? Isn't it better for the prosecutors to know ahead of time? Oh yeah, this is going to be their defense. How can you hide something so important? This is simply fundamentally unfair and almost ridiculous. It's just ridiculous. And then when all of us look at the defense of extortion, those of us who have familiarity with this case think, okay, well, this is pretty absurd. Not only did they wait 9 years to disclose it, but in general, from all the facts that we know, from the circumstances that we know, it seems very out there, ridiculous, unfathomable, excuse me. But is it ridiculous, really, when you consider the fact that this is going to be presented to a jury that came into the trial with a clean slate, that will listen to limited evidence, that will listen to cross-examinations and the presentation of evidence from the state that wasn't prepared or geared to address such a out there, unexpected defense? I mean, it's not like nobody thought about the defense of extortion. This has been thought as a possibility forever, but it has been dismissed immediately almost because of the conversations that happened during the, at the bump, following the bump, Dolce Vita, Matsuri, wiretaps, all the recordings. it doesn't match, right? In our minds, extortion is not possible. In our minds, extortion just doesn't make any sense, okay? But if you're going to be looking at the evidence and you're coming in with this extortion now, and you're going to be throwing evidence that the state never saw, never expected, never interviewed possibly some of the witnesses listed by the defense, because, maybe they were lulled into inaction, okay? Maybe there's a witness listed that the state didn't know about. Maybe they said their deposition. I know that there was not notice of cancellation of deposition. There was a couple of witnesses that were going to be deposed, and then the deposition was canceled. What happened? Did Roshbaum give a representation about what these people will say that was somehow accurate but misleading and lulled the prosecutors into inaction? And then there's the whole issue of what would Katherine Magbanua and Sigfredo Garcia and Luis Rivera have done had the defense notified the police, law enforcement, prosecution, that those people that have just been arrested for the murder of FSC law professor Dan Markel had been extorting them. Okay? If they had said that, if they had notified the police of that and prosecutors about that, what would have happened is that the defendants would know about it, and they would have certainly then testified against the Adelsons, even if it was false, right? I mean, their whole play supposedly was an extortion where they alleged, or where they told the Adelsons, hey, you don't pay, we're going to kill you, or we don't pay, we're going to make, and if we get caught, we're going to make it look like you guys ordered this hit, right? So then why didn't they do that? Well, they didn't do that. Why? Because perhaps the conspirators found a way to indirectly pay for the defense lawyers for Sigfredo Garcia and primarily Katherine Magbanua, because Katherine Magbanua likely was the only person that had any contact with the Adelsons. So they pay for her defense. They get her to believe that she can get off scot-free. She testifies twice, tells a story that has nothing to do with extortion, where she claims she has no knowledge whatsoever about the murder. And so now that piece of evidence is neutralized, right? The most dangerous evidence against the Adelsons and against this extortion defense is from the killers and the middle woman, because they would have known that that's BS, right? If it is BS, they would be the first ones to know. But that evidence is neutralized. The cash evidence, staple money, is somewhat neutralized. There's a ton of evidence, right? The conversations which were guarded at Dolce Vita in the wiretaps and so on and so forth. Now you can try to put a different spin on those conversations. So, were the prosecutors duped or not? What do you think? To me, if we want to help Dan Markel receive justice, I know what my goal is going to be, is to reevaluate everything and see whether the state can salvage this case on rebuttal. I'm starting with the wiretaps. Thanks for watching. Mental Lawyer. I want to help the state correct this fundamental unfairness.